Good morning, I'm Gary DeWaal, and this is Bridging the Week for January 14th through 18th, and today is January 22nd, 2019. I hope you had a good week. Because of the continued partial U.S. government shutdown, virtually no regulatory developments emanated from the Commodity Futures Trading Commission or the Securities and Exchange Commission last week. However, the SEC filed one enforcement action against 9 defendants related to its 2017 discovery that its electronic data gathering, analysis, and retrieval system, known as EDGAR, used for receiving and retaining various corporate filings, had been hacked, and that persons likely had traded on material non-public information obtained through the cyber intrusion. A related criminal indictment organized by the Department of Justice was also filed. The U.S. government partial shutdown continues to wreak havoc on many federal employees' lives, and in some cases, more and more, detrimentally affects persons involved in the financial services industry, as CFTC and SEC staff are not available to address issues that may be important to business as usual. It's hard to believe a way out of this impasse cannot be implemented in short order. In any case, while we wait, let's get started. The SEC filed a civil lawsuit against Alexander Ermenko and 8 other persons for allegedly conducting an illegal trading scheme that relied on material non-public information illicitly obtained through cyber attack on the SEC's EDGAR system. The SEC charged that the alleged illicit conduct occurred from May through at least October 2016. In its complaint filed in a federal court in New Jersey, the SEC alleged that Mr. Ermenko was the architect of the fraudulent scheme. According to the SEC, he initiated his purported nefarious activity in spring 2016 by first sending emails containing malware to SEC.gov addresses that appeared to originate with SEC security personnel. Through this phishing attack, Mr. Ermenko was able to infect several SEC workstations when some SEC computer users opened emails with the malware to illicitly penetrate the EDGAR system and ultimately to gain access to test filings made by reporting entities on EDGAR, some of which contained non-public earnings information that would be publicized by the filing companies in the near future. Mr. Ermenko then sold some of the earnings information to the other defendants who bought and sold securities of the filing companies in advance of the public announcements of such information, hoping to benefit from their advanced knowledge. Ultimately charged the SEC, this illicit activity generated at least $4.1 million in gross illicit gains. All the defendants were alleged to have maintained their last known addresses outside the United States, mostly in Russia and the Ukraine, except for 2 persons whose last known addresses were in California. Most of the defendants were also previously charged by the SEC in 2015 in connection with a similar cyber intrusion and trading scheme involving material non-public information illegally obtained from newswire services. In a parallel action, Mr. Ermenko and Artem Radchenko, who allegedly recruited the parties that traded on the hacked information, were indicted in a criminal action brought by the Department of Justice. Among other remedies, the SEC seeks disgorgement and penalties against the defendants. The Department of Justice seeks fines and imprisonment, among other sanctions. As this embarrassing episode at the SEC confirms, it's not if a cyber attack may occur, it's when it will occur. Unfortunately, the bad folks are too creative and always seem to be one step ahead of the rest of us. The key for all organizations is to enact often recommended measures to help protect against attacks in the first instance, but more importantly, have a good plan and follow it for when attacks happen. I have more ideas on this in the article version of Bridging the Week at www.bridgingtheweek.com. Check it out. And lastly, 2 weeks ago, Michael Kosha, the first person convicted under the Prohibition Against Spoofing enacted under the 2010 Dodd-Frank Wall Street Reform and Consumer Protection Act, requested a federal court in Chicago to grant him a new trial. Mr. Kosha claimed that a retrial was warranted because in his initial hearing, the government had claimed that his pattern of trading was quote-unquote unique and extraordinary. However, claimed Mr. Kosha, the trading data utilized during the trial was for a, quote, narrow, incomplete set of dates, futures, and traders, end of quote. Only after his trial, alleged Mr. Kosha, did the CME Group and the Intercontinental Exchange produce broader sets of data that showed that the ratio of his canceled orders to executions was not unusual and that his, quote, trading activity was the same as hundreds of other traders, end of quote. Mr. Kosha was sentenced to 3 years imprisonment for spoofing and commodity fraud for 3 months of trading activity in 2011 following a criminal trial in 2015. As I wrote at the time of Mr. Kosha's sentencing, it seemed somewhat draconian that Mr. Kosha was sentenced to 3 years imprisonment for violating what was then a new law for which he already paid substantial civil penalties, which on its face appeared to prohibit at least some legitimate trading practices, and which may not have given him adequate notice of prohibited conduct. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.